absolutely everything possible to have that judgment enforced, to make sure that that debtor now pays that money to that creditor. And what you'll see, and these cases really make it totally clear, and we've honestly seen this same pattern over the last 15 years, is that the judges do have certain tools to reach assets that someone tried to abscond with or hide as a reaction to litigation. You know, you can't move assets once you're aware of a claim. That's a fraudulent transfer issue. So that all those transfers can be unwound. You can't do things that aren't really like a trust. You can't fake it. You've got to have a real trust likely for someone else. If you fund an offshore trust, you really have to use an offshore trustee. The assets have to be offshore. You really have to do it on a sunny day. So I think you're going to find the cases where people didn't do that, and what the judges do, kind of an interesting twist on asset protection.
And let me also just add, if you have questions and you drop them into the question box, we encourage that. We'd like to address any questions you have as we go along, and we'll answer them as we go along. We do have just an opening question here. Somebody asked if there were PDF slides available. We can make those available after the seminar. I'm happy to send them out. The outline that is available does contain all of the information that's in the slides in just outline format. But if you would like those slides, let us know. We'll go ahead and make those available as well. Now back to our previously scheduled recording. Asset protection is not, you know, this is some of the misconceptions. It's not about hiding assets. It's not about dodging your creditors, evading taxes, shirking your obligations, so to speak. It's legitimate planning that, when done properly and timely, stands up. And we do Gary does planning. I've done a lot of litigation in this area, and it can be a very effective tool. So let's jump into some of the methods that we want to talk about here. Again, these are examples that have been posed of, you know, what about if I do this? And so one is using so-called anonymous trusts or entities to own property. And the idea with this, and this, I saw an example where somebody was selling on the internet anonymous land trusts, and you should use a land trust, anonymous land trust, to hide your ownership of whatever asset that you have, so if somebody tries to sue you, they won't know who you are and won't be able to figure out what you own. And therefore, you won't be responsible for any liability that might be created by that asset, or that asset won't be available to creditors because they won't be able to figure out that you own it. Now, for any attorneys out there that we have listening, I know we have a few, you know that this information is going to be available in discovery anyway. But let's take a closer look at this. You know, what are some of the potential issues with, you know, using a land trust for anonymity? And Gary, you want to kind of hit on some of those?
Well, years ago, you know, I think in the late 60s, Massachusetts passed a land trust statute, and a few other states adopted a similar statute to create anonymity. So if a large group of investors, like for instance with Disney, I think Disney did it actually. Disney was picking up property in Florida, obviously, and wanted to be totally anonymous. At the time, the Delaware LLC did not exist. So the way to do that, in light of the fact that deeds are recorded, so you see a transferee there, to avoid anyone knowing about the transferee and looking up any information at the Secretary of State level. At that time, you'd have to mail away for it, but you could get it. They used a land trust, so you could appoint an outside trustee that no one knew, and nothing would be really triggered by the fact that you looked up somebody and they were completely, you know, the underlying Disney entity was completely anonymous. It's not really a protective device. What we found over the years is that, you know, in light of the fact that Delaware now does not require hardly any information apart from the registered agent on its articles of organization, that if you want anonymity, Delaware LLC is very good. Of course, it also provides the protections of an LLC. The protections associated with the land trust are very unclear. It's really its use is very, very limited practically, but there are some, you know, internet packages and claims by generally non-lawyers selling land trusts. We don't recommend it. And as Eric will get into, the whole anonymity thing is really kind of silly. If someone sued or someone is sued based upon a particular property, litigation is going to ensue. The litigators know who to sue and how to sue, and of course, after litigation begins, there's discovery. So everything associated with these properties is going to get found out. It doesn't have to be publicly available to be available to the litigation team. And of course, the IRS and other government agencies have even more discovery power. So these idea of being anonymous is really of very limited value.
Yeah, and I put a scenario here. We included this one about, and this is where we thought of this idea. Somebody was telling us talking about owning property, and that way, if I have an apartment building and somebody in the apartment building wants to sue me because they're injured or something happens on the property, well, they won't have any success because they won't be able to find me, won't be able to figure out who owns the building. Well, first of all, if somebody slips and falls on your property, their first place they're going to look to sue is whoever owns the property. And so if the property is owned by a trust, they're just going to sue the trust, and those assets are going to be available on, you know, the building and anything else. But certainly that building and the equity of the building is going to be available to satisfy a claim. And then through that lawsuit, of course, then you have broad discovery powers. You're going to ask for tax returns.
This came, and this example that Eric's talking about, this walkthrough, is really because you saw something on the internet advocating.
That's exactly right.
I mean, it's just like
somebody on the internet was saying this is, you know, it was a guy had a little video actually, and he was I don't think he was a lawyer, but he was an asset protection expert. He was saying this is one of the things that you need to do, and it's just bunk, frankly. Now the reality is there are times that anonymity is desirable for other reasons, but it's really not going to be effective for asset protection. I mean, may it be, well, if somebody can't find your stuff, maybe you don't look like the low-hanging fruit to some of the personal injury lawyers, potentially, but a lot of these folks, if they're trying to sue you, they're pretty savvy, they're going to figure it out. Use an example where we did have a case. We had a husband and wife, business partners, split up, and the husband was pretty abusive towards the wife, and she wanted to create another business, but she didn't want the husband to know that she was involved in this business. She didn't want him to know he was around, the ex-husband, I should say. And so she wanted to start the business and have the business not have any records in Florida public records being traced back to her. Well, there's a valid reason to have some anonymity, and so Gary can set up that structure using Delaware entities and achieve anonymity to do business in Florida through the entity. But it's for other reasons. It's not going to be the be-all, end-all of asset protection. So let's talk about. Let's see. Hold on. We got another question here. I like the questions. And oop, my question disappeared. I think I had a question, and oh, here we go. Does Nevada have corporate registry with anonymity like Delaware?
No, Nevada is not. It's a fairly small disclosure, but it's much more disclosure. There's addresses and similar information that can link back to the owner. It's not as anonymous as Delaware, is the answer.
And Nevada requires, I think, the manager. So
yeah, I think you have to list some manager.
Now there's companies. I know that there's offshore companies that will act as your manager, but then you go through. But you have to list somebody as a manager in Nevada.
It's not as easy for whatever reason.
Nevada is good for other asset protection reasons, however.
Yeah, the trust's very good too.
So let's talk about keeping assets offshore or using offshore protective structures like offshore trusts. And the benefit here is that the offshore structure puts the assets outside the reach of U.S. creditors. Gary actually does a lot of foreign trusts, so I'll let Gary talk about what some of the issues are with that, and we can use this case as an example that we had here in Central Florida not too long ago.
Yeah, this is a great, I mean, it's a great case of example of what judges will do to enforce their collection side, the collection side of their judgment. In this case, this is Miss Barbour defaulted on some very large real estate-based loans and did some reactionary transfers to a Nevis LLC. The court wasn't very impressed with the Nevis LLC. It was a Florida Middle District Court. Was not very impressed and basically disregarded the LLC in light of the fact that she was here and all the assets are here. This really wasn't a shock. Although, we study this conflict of law issue academically. I mean, basically she had a Nevis LLC, and under what's called the internal affairs doctrine, our courts are really supposed to respect the statute of organization. And for instance, the Florida LLC statute talks about the Florida LLC, the Nevis LLC statute talks about the Nevis LLC. So if you're a Nevis LLC, even if you're in a Florida court, they're supposed to follow that Nevis statute. This is fantasy land stuff, though, because once someone owes $62 million and the accounts are in Miami, say goodbye to the accounts because of the fraudulent transfer issue and the fact that it was all kind of a sham. So she lost the money, and the court just said, we're going to use Florida law. We're going to use the Florida LLC, even though you have a Nevis LLC. Is that right? Technically, probably not. Probably not. But you can pretty much expect that to happen. Now, if you rewind, interestingly, and let's make a hypothetical that Miss Barbour had already purchased a property. The property maybe was doing well for a few years. During that period, she may have set up a Nevis LLC or a Nevis trust that owns a Nevis LLC and funded that LLC with earnings from the property. There's no default on it, and she wouldn't have expected any default with respect to the property. So let's say she funded that entity. The LLC and the trust are a little bit different, but I'm not sure. I think that for our purposes today, let's just say it's offshore. The money, the account's offshore, and she used a foreign manager, a foreign trustee. Okay, fast forward. She defaults a few years later. Well, Eric can tell you, because we do the litigation side, that that's a much different case. That's a much different case. If she defaulted because of the mortgage crisis, and she had previously, years before, funded a Nevis LLC and with assets offshore outside the jurisdiction of the court, well, those two factors are going to make it very difficult for a Florida collection lawyer to get to that money. What do you think about that? I think it's a totally different set of circumstances. Yeah,
the other thing Miss Barbour did here was she sold homestead property, and that, there's an argument there that the funds from that property could have been preserved in just a simple homestead account if she had intended to use it for another homestead. She instead took money and moved it in and out of several other accounts in reaction to the judgment.
Yeah, she blew the homestead.
And those reactionary transfers, you get the judge's attention to, and we're going to see another case here in a few minutes. I've been in that situation from litigation where a client comes in, and the worst is when they've actually had some planning done, but they haven't fully implemented it, or they forgot about an asset, they forgot about an account. They say, what about this? I've got this. You know what? That thing, it's moving. Right. Sometimes it's worse to call attention to it. Just leave it there and deal with it. Now there's
sometimes
exceptions.
You can consume it too.
Yeah.
Sometimes you don't move it, you consume it, and the protected assets you don't consume.
So she had some things she could have done, but the big mistake that Miss Barbour made was keeping that money in an account in Florida and putting it in a foreign LLC. If she'd established that LLC several years prior, and had that money in there, it would have been a different situation.
Or if she would have had it offshore and
sure.
years prior.
Have that money in an account offshore, have it in assets offshore, then definitely, even if she had it offshore, frankly, the court has some other squeeze mechanisms it can use, potential contempt powers, and we have one of those cases we'll talk about as well.
But they likely wouldn't have if she'd have done it years before.
But if she'd have done it ahead of time, she'd have been safe. There was some good language in that case. The $62 million deficiency judgment. The language in the LLC statute says that you could foreclose a single-member LLC. Essentially, if it appears that the LLC, that the collection is unlikely, the LLC is unlikely to make distributions to satisfy the judgment, and the judge said basically with $62 million owing to Wells Fargo, it's pretty unlikely that that's going to get paid anytime soon, so he allowed the foreclosure of the LLC. A couple of things to add on Barbour is it distinguished another case that we liked from a couple years ago, the Sargent case, where there the assets were not in Florida. The assets were outside the jurisdiction, and the court in Florida, the creditor's attorney went and said, we want to compel the turnover of stock certificates. And the court said, we've got no power in Florida to compel turnovers of assets that are in another jurisdiction. You have to go get those assets and bring them back here or sue, use the proper remedies through the Foreign Judgments Act. The interesting distinction there, one thing that we note, a lesson from that is that Sargent involved corporate stock certificates, and as some of the folks know, LLCs did not require certificates. And in Barbour, the court said that the LLC interest was an intangible interest that attached to the debtor. The debtor's in my courtroom, so the interest is here. And when you compare that to Sargent, where the court said, even though the debtor's here, the stock certificates are somewhere else, we wonder if Miss Barbour had simply certificated that interest and put it in Nevis with the manager, if there would have been the same result. Now, given the other shenanigans, perhaps the outcome would have been the same.
She had the fraudulent transfer issue, so she was very exposed because she was reacting to a current creditor. In Sargent's a very important case because it was a commercial case. It was a Miami lawsuit, just a commercial lawsuit. I think it had a strip mall was involved or something. And this, Al-Salah, he had a Dominican entity, and the certificates were offshore. I think he had a United Arab Emirates entity as well. But the key to it was that there's a line of cases where once you owe money and you've got these stock certificates or bank accounts offshore, that the plaintiff's lawyers were moving toward and having some success with causing the court to force this defendant to turn this stuff over or go to jail for contempt of court. And the Florida appellate court, so it's pretty good law now in Florida, said no. That is not the procedure. And honestly, academically, it's not. But that's where the cases were going because these judges wanted their judgments enforced. The procedure is you get your judgment here, and under rules of reciprocity called comity, you can take the judgment to the Dominican Republic and try to attach those shares. Of course, it's very difficult because all of a sudden the shares are gone from Dominican Republic and the rest of it. But it's a very interesting case from the perspective of moving stock certificates or leaving them in another jurisdiction.
Yeah, and the takeaway now is if you're going to use an offshore LLC, certificate the interest and send the stock certificates over there. Do it in advance. Do everything properly in advance, and we can take these cases and learn lessons from them. But it's important when using offshore. We include the offshore discussion. It's important when using offshore mechanisms that you have the trustee or manager and assets offshore. And we'll talk about that a little bit more. There's a case where, I read recently somebody thinks they've gotten around that and figured out a way to protect real estate in Florida or otherwise in the U.S. through an offshore mechanism, and we'll see if that holds up. Also, when using offshore trusts, we've talked about this. We did a separate seminar just on offshore and self-settled asset protection trusts. Understand there that if you create a situation where the assets are unreachable because they're offshore, but you become a debtor in an action and the court thinks that there's shenanigans going on, a fraudulent transfer or something else, and does order you to make those assets available or repatriate the assets, and you refuse, you can be subject to contempt. And there's a couple colorful cases where people have gone to jail. There's the Anderson case involving the U.S. v. Affordable Media. There was the case involving Stephen Lawrence, who was a commodities trader. We've had a few cases where people have gone to jail or been threatened with jail.
And the bankruptcy in that situation, if the defendant ends up going bankrupt, jail is more likely.
Oh, that's even worse. Yeah.
The court has even more power to put you in jail for contempt.
We often say, use asset protection or use bankruptcy, but what you don't want to do is have an asset protection structure and then end up filing bankruptcy. It's usually not. The whole purpose is to stay out of there. Bankruptcy courts, it's a totally different ballgame. The bankruptcy trustee and the bankruptcy courts have and will exert a lot of power and authority, including the authority to put debtors in jail. So let's talk about, this is one of my favorite, the use of purportedly exempt accounts. And the big one here is the use of the Delaware bank account. This came to light a couple years ago. A lot of people were doing this where they put money in a Delaware bank account, and Delaware has this old law that says that banks and the accounts that they hold are not subject to attachment and garnishment. So the bank gets a creditor gets a judgment against me. I just go to Delaware, open up a bank account, put all my money there. You can't garnish it, you can't attach, you can't touch it, and I stick my tongue out and say, na 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 na, come get me now. And does that work? Maybe. We've actually had clients who've used that with some effectiveness combined with some other other tools.
It's like anything else, it's likely going to work if you don't do it as a reaction to someone having a claim against you.
Well, that's right. The client that we've had that actually kept a substantial amount, he had that account for years. So if you're going to do the Delaware bank account, there's some ways to do it. You can actually have the account held in a multi-member LLC and do that and establish it ahead of time and have it in place so that if you ever need it, you have it. There's some costs involved, and there's only a few banks. And one of the things to realize is, one of the big issues here is it only works if the bank is only in Delaware. So it's not going to do you any good to go to Bank of America in Wilmington, Delaware, and open up an account. Right. Because if I'm a creditor and I want to get information or attach that account or get a garnishment order, I'm just going to serve my local Bank of America branch here, and Bank of America is going to freeze that money.
And a few of the banks, the bigger banks, actually have independent subsidiary banks formed in Delaware for that reason.
And so you generally have to go to Delaware, and I will tell you from experience that it's not impossible, but it's not easy, and there's costs involved. The few banks in Delaware that do cater to the non-Delaware resident and will allow you to have an account, they're going to charge you for that. Not as much as if you were doing something offshore, but it's something to consider. So if you want that bank account, it's possible to do. If you contact us offline, we can even maybe point you in the direction of how to do that. But there's a little cost and a little bit of a logistic complication. Now here's an additional risk with this involves the Delaware bank account and again reactionary transfers. This was sort of an under-the-radar case that occurred about almost 2 years ago here in the central, in the middle district of Florida in Orlando. It never went to judgment or any decision because the parties ended up settling, but we knew some of the players involved, and there's some lessons to be learned here. And this is the Thompson, or the Travelers Casualty and Insurance Co. v. Thompson. The citation is in the materials that we've handed out. And in that case, the Thompsons had a construction company that was doing work under a bond, and the bond ended up getting called by, I it was somewhere in South Florida, Broward County, and the travelers had a provision in their indemnity agreement that allowed them to require the individual guarantors to post collateral to secure their bond claim. And the Thompsons did not post the collateral. Instead, Travelers was forced to go to court, and they sought an injunction requiring the debtors to post collateral as required under the agreements. The court granted the request and ordered a bond be posted in the amount of nearly $1.5 million. Now, this was also while this was going on, while the claim and the demand were being made and the lawsuit was filed, the Thompsons again created several LLCs, from what we understand, moved property and money in and out of these different properties, sold some real estate, ended up buying a homestead, and then they moved a big chunk of cash up into a Delaware bank account. So, and this is really at the height of, one of these particular banks in Delaware was being sued a lot, and we started seeing this as it was a regular occurrence as a reactionary mechanism to
there's
claim.
a few practitioners that just made us aware of it, and it's very interesting because this, as they become more popular, the judges become more aware of them, and as if they think it's abusive, then they're going to look at the facts, and the facts here again will tell you that this was not done before the default on the surety bond. If it was all done and they had their homestead in their Delaware account before the default or before any financial issues, it's just judges are very reluctant to tamper with any of that. But now we have a runaway defendant who owes on a surety bond, and it's very interesting because the Delaware law is very clear, and that cash is in Delaware. But let's see what the judge did.
Yeah, so the judge grants Travelers injunction motion and orders that the debtors, in this case, the defendants, post a bond of about $1.5 million. Well, again, for our attorneys in the audience or anybody who knows anything about the authority of the court, you now have a federal judge that's told you to put $1.5 million into the court registry. You got 10 days to do it. Is that decision correct? Arguably, the injunction is a remedy for irreparable harm, something that cannot be cured with money alone. Normally, money damages are not something that you can secure with an injunction, regardless of whether or not the defendant will likely have an ability to pay. So, from that perspective, it appears that the court went off went outside of its authority to some degree by ordering the injunction in the first place, because it was just something that could be cured with cash. But you don't have time to appeal. You got 10 days, and now you've got to go tell your client, well, here's your options. You either post a bond and put the money in the bank, or put the money in the court, bring it back from Delaware and post it, or in 10 days the court could fine you in contempt, and you could end up sitting in jail until you do post it or pending an appeal. And what ended up happening is that case ended up settling pretty quick. I mean, the Thompsons, the poor folks, they just had no real, sort of a Hobson's choice. They either faced jail time or post a bond, and they were forced to get a settlement. And give credit to the attorneys who handled that case for Travelers, because they really put the pressure on. And like I said, we know several of the folks who were involved in that case, and I'm sure that the Thompsons were well represented in court. But ultimately, the judge really used his inherent powers that you have as a federal judge to put the pressure on. Mm-hmm. All right, so let's look at some derivatives of this. An attorney called me. This was within the past year. Somebody that I was involved in a case with, a very sharp attorney from Massachusetts, calls, but he doesn't do a lot of asset protection. He says, "Hey, I got a question. Got a client, had a judgment entered against her. She's been told put the money in this Delaware bank account. This lawyer in Delaware is telling her put the money in the account and then create a Delaware LLC and put the account into the Delaware LLC, and then you're the LLC owner of the account, creating two layers. It would be a single member LLC. What do you think of that?" Well, what are the problems here? Gary, I'll let you take this one. This is fun.
Well, of course, you have this Travelers versus Thompson issue where you're reacting, and that rarely works. So right off the bat, this isn't something we would take. One foot in the grave, as they say. But beyond that, you know, as a little background, we used to have this issue where people would do their own asset protection, and for instance, they'd go in and they'd all have a LLC. Be 5 investors have an LLC. They buy a building or something like that, and then 2 of them would take the building in a corporation. So they have the corporation that own the LLC. So where the LLC provides quite a bit of protection against someone reaching the asset if the individual partner is sued, once they put it in a corporation, the plaintiff can take the corporation. So they've completely eliminated all the protections associated with the structure. So this is kind of similar. I mean, once you decide to form a single member LLC, you got to be very careful. You got to be very careful because there's a number of rulings, about 6 rulings now, including one in Florida called Olmstead, that say basically if you own a single member LLC and someone sues you, they can take your single member LLC. So in this case, regarding the Delaware bank account, maybe the Delaware bank account works. The Delaware statute says you can't attach it. If the judge decides not to put her in jail to force retrieval of that money, she may get away with it. But if she puts it into a single member LLC, where was she, Massachusetts? Massachusetts is not very protective. So the judge could easily do what the judge did in the Wells Fargo case and say, look, I'm going to take your LLC. We don't really care about the Delaware law because you've wrapped up that Delaware account in a little package with a bow, which is called a single member LLC, and we're just going to take that. So she could have eliminated, she probably would eliminate any protection associated with Delaware LLC, a Delaware account.
Yeah, so you simply foreclose under your local law, relying on the authority or the analysis and the argument that was made in Barbour, foreclose on that LLC interest under your home state law that allows foreclosure of the single member LLC in Massachusetts or Florida. And now you show up at the bank and say, I represent the LLC, I'm the manager and the owner of the LLC, and I'd like to empty out the account, please. You're better off, obviously, advanced planning, but better off probably just leaving it in the account by itself. Now, contrast that with having a multi-member LLC not subject to foreclosure. Maybe you have a multi-member LLC and the manager is the only one authorized to access the account, and the manager is outside the jurisdiction of wherever you are, and maybe it's too complex to keep the assets in an offshore account, and you want to use Delaware, and if you've had that Delaware account open for some time, different situation. And
also when you obviously when you give it away, litigation's easy. So even the most basic, we have a separate seminar on basic planning. Even the most basic planning. So if the account is husband and wife and only the wife sued, or you put it into this multi-member LLC and that's not available to creditors in general, what happens is when you create a legitimate layer is that the litigation becomes very costly for the plaintiff. So the value of whatever they're trying to get to has got to be much higher for them even to pursue it. Most claims, under several $1 million that are difficult because structurally collection is nearly impossible or very expensive, just don't happen.
Let's pop on again. If anybody has any questions and you drop them in the box, we'll do our best to address them. And questions are welcome.
And we'll get the colorful one in at least.
We've sort of done it. Yeah, we have which colorful one here? Spousal transfer. So on Monday we were asked about this. So Gary and I did a seminar for MBI. We enjoyed doing these. It was a business law boot camp on Monday morning, right when I was coming back from vacation, and it was on LLCs and forming and forming LLCs and some initial considerations. And one of the questions that came up is, well, does it help if I'm in a high-risk profession, I keep assets in my wife's name or my husband's name, whatever the case may be.
Which is very common.
People do that.
They do it.
And here in Florida, you have the benefit of tenancy by entireties, which creates a separate. If an asset is owned as a husband and wife TBE, it's not available to the individual creditors of the husband or the wife. That's the best way to hold it. And here's the issue here. So the benefit is, well, if I'm a lawyer, I may be sued. I keep assets in my wife's name, or if I have been sued, I transfer everything to my wife. And there's a case where that happened, and we knew some of the folks involved. In fact, Gary almost was an expert witness in the case. And it's this one here, this Grief v. Cahan.
And there was a lot of grief involved.
And so Grief was, and the law firm also. Cahan was a lawyer, and the law firm was sued. And here's what happened. Mr. Grief made some money, but part of it was made as one of Bernie Madoff's investors. And anybody who knows anything about the Madoff issue or any Ponzi scheme for that matter, there's the ability for the law provides a mechanism to go back and claw back claims of profits that people make in a Ponzi scheme so that everybody can be made equal, if not whole. And that's what was going on in Bernie Madoff. And so Mr. Grief was one of the folks who was subject to a claim from the Madoff estate and the trustee seeking recovery of some assets. And so he went to his lawyers who were representing him in the Madoff case and asked about asset protection. And they suggested that he was a Florida resident, they suggested that he move all of his assets over to his wife under a post-marital agreement. And what I understand the terms of that, or the post-nuptial agreement, the terms of that agreement were essentially so that it would look like there was adequate consideration on both sides. I'm going to give you, honey pie wife, everything that I have right now, and in return you agree for the next however many years, 3 years, that you're not entitled to any, if we get divorced, you're not entitled to any more of my income for the next 3 years. And so they signed this agreement. He paid a substantial, he paid, well, close, almost halfway to 6 figures for this planning and advice. And of course then the question is, well, if I put all the assets in my spouse's name, and his wife, by the way, was apparently a pinup model and substantially younger than he was. So the question is, well, what if your spouse divorces you? And that's what happened. And so
it was very, very poorly done. It was very, very poorly done.
He had the option there of potentially making these assets be held TBE. Obviously, he had about $7 million in property. He moved over to his wife's name. He could have done advanced planning.
Beneficiaries of that trust.
Yeah, he could have created a trust and had other beneficiaries. Instead, it was set up entirely for his wife, and it took her about 3 months to file for divorce. Again, that was the case ended up settling, but we were in discussions. Gary was potentially going to be involved in that case at some level.
Well, the advice was so bad, was the problem. Anyway, it was another reactionary transfer involving offshore assets. But what happened was he created another plaintiff because he basically gave it all to his wife.
And then to add insult here, what happens with one of these transfers, and it's just good knowledge for anybody who's in this situation. So the lawyers go and they say, well, transfer everything to your wife. Well, the wife then got sued by the Madoff trustee as the transferee of a fraudulent transfer. So she's sued, and so she's not escaping this claim anyway. And I think the claim was around $2 million, so it wasn't everything. But under the post-nuptial agreement, there was an indemnity provision, so she turned around and brought a claim against the husband, who was now penniless, to indemnify her for the claims being brought by the trustee. And I heard a rumor through the grapevine that the husband literally was penniless and actually living, I think this was in the lawsuit there, that he was actually living with his mom when the lawsuit was filed. So quite a turn of events for him. Ultimately, that case settled out of court when the law firm was sued. And frankly, that law firm and that lawyer who gave that advice, they were lucky not to be defendants in the Madoff claim, because
Yeah.
we've seen, there's cases in Florida that say that the attorney or the advisor is not liable for fraudulent transfer advice, but we've talked about this in prior seminars. We believe that some recent rulings, particularly one from the Supreme Court.
Federal.
Yeah, the federal Supreme Court, the Husky ruling last year, that's going to call that into question. So
And Madoff, is Madoff a federal claim?
Madoff is a federal claim, federal clawback. And so you have potentially a claim against the attorneys who told them to do this for advising them to conspiracy to commit a fraudulent transfer, aiding and abetting, other accessory liability claims.
One thing we recommend if you get involved in this kind of work, well, obviously we recommend completely avoiding any reactionary transfers. But just as a general policy from clients, you may want to get what's called an affidavit of solvency, which is basically their representation that these transfers don't create their own insolvency. And what that does is it gives you notice. It puts a lawyer in a position to say that they weren't involved with any fraudulent transfer, because one of the elements of fraudulent transfer is insolvency.
Let me add another. We were talking about this earlier. The attorney's fees for helping somebody who is involved in an obvious fraudulent transfer. There's going to be a claim. I don't know if it's come yet, but there's going to be a creditor who's going to make a claim on the attorney and say, give us the money that you were paid. And the attorney's going to say, well, I provided services. There was no fraudulent transfer because it was a reasonably equivalent exchange of value. And what the trustee or a court or some argument that's going to be made, I'm I guess predicting this, is going to be, well, if you gave somebody advice that was clearly a fraudulent transfer, there's no value to that legal advice, and therefore they paid you for nothing. There was no consideration, and the money that you received is also a fraudulent transfer. So if you don't get hit on accessory liability, you could end up having a claim for fraudulent transfer yourself. Just an FYI. If anybody's interested in that, we've done a whole other seminar just on accessory liability, and we can talk about that with you. Finally, let's talk about self-settled trusts. And this is what we'll wrap up with here as we come into the final few minutes. And self-settled trust is essentially where you're creating a trust where you establish a trust and you're the beneficiary. And Gary, you want to hit on that one?
Sure. In the late 80s, early 90s, what had happened was several of these former British colony islands figured out that the U.S. does not allow you to form your own trust. Basically, you could form one, in Florida, for instance, but it's not protective of the assets. So if the grantor / beneficiary is sued, the assets are available. So what some of these island nations, like the Cook Islands and Nevis, and there's several of them actually, said is, look, we're going to offer a trust statute whereby you can form a trust for yourself and it's fully protected. So that's a self-settled trust called an asset protection trust. As we had mentioned, if you form one of these, there's a couple of jurisdictions that are much stronger than the other jurisdictions. We use Nevis, West Indies a lot. It's a very good statute. But you really need to have the assets offshore, because if you're sued on something domestically, the claim's always going to be that the trust is a sham. For instance, under Florida law, such a trust would not protect the assets. So they're very effective, but they have to be set up properly. A self-settled trust includes, like for instance in Florida, the revocable trust. So if I got to say, once a week, maybe twice a month, people will come in, they have a revocable trust set up as part of their estate plan, and they literally believe, because the lawyer told them that once the asset is titled in the revocable trust, it's not available to their creditors. It's not true. The revocable trust creates no protection over those assets at all. It's not a trust that you set up for yourself, especially a revocable trust that you control, does not protect anything. It just avoids probate if set up properly. It's a will. It's a fancy will. So anyway, following these colonies setting up with these trusts, which became very popular, we now have 16 states, started with Alaska and Delaware, where you can do your own trust. It's pretty interesting. I mean, you can form your own trust, and it's protective under the law of, for instance, Delaware. The thing is, if you don't do the foreign trust and you decide to do the domestic trust because you want to keep your assets in the U.S., you have to be very careful with it, okay? Because of this idea that if you're not from the state that offers the domestic asset protection trust, the local court is going to just ignore it. We have several cases. The biggest case is the Huber case, where the factors are, for instance, where are the assets, where's the grantor, settlor, the guy who forms it, and where are the beneficiaries, right? So if you form a Nevada self-settled domestic asset protection trust, and you use a Nevada trustee, and the assets are in Nevada, even if you live in Florida and you're sued and the Florida court says, you know, I want to get to those assets, well, I think what's going to happen is that judgment that you lose is going to really have to be domesticated at this point. It looks pretty good in Nevada. And if it goes to Nevada for collection, that judge is much more likely to enforce that ruling.
We have one of those right now. It's exactly what we're doing. We're arguing jurisdiction, representing the trust from Nevada, that there's no personal jurisdiction over the trustee or the entity
It's a
here.
good argument.
And we want to force it back to Nevada. But you've got to have everything in Nevada. And
yeah, or do your best.
And have the assets there, because otherwise then you run the risk of a court to say the Barbour situation. Huber, we did a whole seminar on this, and the risk is that a court just basically ignores the foreign law, says we don't have these trusts here in Florida or whatever jurisdiction you're in, and treats it as under local law and ignores it.
Yeah. So I think we're pretty much out of time.
Yeah, I do want to mention this one. We've got about 6 minutes. We can take any questions. The requirement for some CPE is to be on for 50 minutes, and it's about 12. We've been going for 50. Actually, we've been going for 49 minutes technically, so we got 1 more minute. But I want to hit, with trust, we talk about keeping the assets outside. I think this is interesting because I saw this interesting article and it caught my eye, and it was somebody who said, well, you can protect personal property in the U.S., including and real property and real estate through a foreign trust. And so that caught my eye because we've always told people you don't really want to own real estate in a foreign trust because a court in Florida or whatever state jurisdiction you're in can just ignore the foreign structure under certain circumstances. And so the question is, well, how would you avoid that situation of a court ignoring it? And it was a pretty good idea. The concept is you have your real estate here in the U.S. It's owned by a foreign trust or foreign entity, and then you have a mortgage from an independent lender that encumbers the property up to 90 or 95%. You take the proceeds from the mortgage and you put it into the other trust, and then the interest from those proceeds can be used to pay on the mortgage. All in all, not a bad idea, except, again, if you run into a situation where a court engages in what's known as a substance over form argument, where the court really looks through the form of what you have here, in this case a mortgage with an encumbrance, and actually says, well, at bottom, what is really going on here? And essentially the court's done this analysis in the past. There's a recent case in Nevada, and it's in our materials. We won't have time to get into it, but it's the Pivaroff case. And in Pivaroff, that's essentially what happened with an IRS claim, is the Pivaroffs lived in a penthouse in Nevada that was encumbered by a mortgage through another entity that the Pivaroffs were somehow related to. And the Nevada court just ignored it and said that, the mortgage is a sham. I'm going to disregard the mortgage and let the IRS foreclose and take an interest in the asset. And so then the question comes back, well, how do you get an independent lender from offshore to participate in this idea? I'd be interested to see if you can get a truly independent, unrelated lender to participate, and what's it going to cost? With them having to know or understand that one of the risks, if I'm advising that offshore lender, one of the risks is you may have a court that just gets pissed off or chooses not to honor this arrangement and ignores it, and your encumbrance is gone. So with that, I think we've hit on that. We didn't get to talk about pivot off much, but if anybody's got any questions, feel free to shoot us an email, contact us offline, give us a call. And finally, I do want to also add, we didn't talk about reciprocal trust. That's another interesting concept. We put some materials in. So there's more in the materials than what we've covered today. That's typical for these seminars. We can go on. But we have a couple seminars coming up for different groups, and one is for the Orange County Bar. We're going to do 2 hours of time for the bar in their October seminar. We have one topic pretty firm. We're going to talk about asset protection and cryptocurrencies. But if anybody's got any ideas for a topic, like, hey, why don't you talk about this, feel free to bring them to our attention. If it may be something that we've seen or dealt with, or if not, we'll take a look at it, figure it out, work through, and it might make for an interesting seminar topic. And we appreciate any input or feedback that you have. And with that, thank you very much, folks.
Thanks
Enjoy
so
the
much.
rest of your day. Bye-bye.